All rise.
Further hearing in the appeal, Tomlinson and others against Birmingham City Council.
Yes, Mr. Arden.
Well, I'm quite conscious of time. My agreed time runs till 12 o'clock.
Well, you might be able to finish sooner. If you can, so much the better.
I'm going to try to. I have been trimming over the evening, as it were.
Let's make some progress.
And in any event, Ms. Leaven will be making some issues on issue 2 as well, so I shall rely on that. I was going through the cases in support of our general proposition that one looks at the scheme and only exceptionally the individual facts might even raise an argument for moving outside the general approach. As Croydon obviously has been to House of Lords, I'm not going to go to it in any detail at the Court of Appeal, but I would like to refer to a couple of paragraphs in it. It's volume 4, tab 17.
Seventeen's Court of Appeal.
Yes, I intentionally wanted to go to that, Lord, because
Yes.
Mr. Justice Ward, paragraphs 70 to 71, relying on a case called Feld, in our submission rather spells out or gives a little meat to why it is that administrators can be regarded as impartial and that the independence is only a formal want of independence. And he says there, nothing to cause me to recount the views. Trained decision makers should not be treated as inferior beings intellectually unable to approach the task with an open mind. In my judgment, the case was one of bias that was being alleged. The reasonable member of the public taking a balanced view is unlikely to be unduly perturbed by the close connections to the social workers and employers who have to find the appropriate accommodation. It cannot realistically be said that the lack of independence and impartiality arising from no more than the organisational structure can so affect the social workers' decisions as to be incapable of cure by judicial review. I reject the submission that the very essence of the right has been impaired, so the concept of full jurisdiction accordingly requires the court to take the decision afresh or remit it to some other body fully independent and manifestly impartial. There is no such body at the moment. What Lord Justice Ward is recognising here in our submission is something that's implicit in the European and domestic discussion of the administrative rather than judicial model of decision-making, and is spelling that out, that it is an administrator's job not to do people out of their rights, but to administer their distribution. Actually, and at risk of sounding simplistic, trained local authority housing officers are by and large there to house people. There's no conscious or unconscious intention to approach applicants unfavourably. To house people is their job. And if anything, one would expect housing officers to lean in favour of applicants. The authority's wider interest is to prevent homelessness, not to generate it. Nor is the spectre of member pressure to be assumed. We're not saying it can never happen. But there is, if I may say this, perhaps a mild tendency in some cases for courts, I dare say this, to bring their own experience of local government to bear, whether derived from practice or otherwise, or general knowledge or what have you, sometimes without appreciating some of the considerable, some of us would say seismic changes that have taken place in local government over the last decade or two. In particular, members are now statutorily required to commit to a code of conduct which has to and they're disqualified as members if they don't sign up to it after a period of time. The Code of Conduct has to contain provisions, some of which are mandatory and set by government, by statutory instrument. One of which I thought it was worth, and breach of these provisions leads to sanctions, not just committee within the authority, but to something called the Case Tribunal, the Independent Adjudication Panel for England, and can lead, again, to disqualification as a member. This is all under the Local Government Act 2000. And the reason I mention that, if I may, is just to finish that point. I confess I did wonder on the way here whether we should actually have produced this. Obviously, we'll produce copies if it's helpful.
I haven't detected any indication in the argument or in the correspondence we've seen that there was any attempt by officials to put, by elected councillors to put pressure on the officials. And we are dealing with a relatively low-level individual fact-based decision.
Yes, I'm simply addressing the generality
Yes.
of it. Melanie Fenn will say there's no difference between officers and members and so on. And one of these criteria, one of these conditions of the code is that members must not do anything which compromises or is likely to compromise the impartiality of those who work for or on behalf of the authority. In other words, that impartiality element, this doesn't follow the case law, by the way, that impartiality element is embedded in the work of officers in modern local government law structure. That's what I wanted to bring out. It's not a casual or impressionistic thing. It's actually there. Going back to Croydon, at 75 to 77, we have again the whole scheme approach leading to the point at 77, we don't really need to read it out, but at 77 it's not enough to look at section 20 alone. The whole of part 3 is relevant. At the end of the process is the decision as to what sort of accommodation within the wide range of section 23 is appropriate. Well, actually that is the exercise that we're engaged in here. I'm going to go on then to right at the House of Lords very briefly, which is volume 5, tab 30. And it is the speech of Lady Baroness Hale, paragraph 23. Well, perhaps I can back up into 22 halfway through it. I'm sorry. Tab 30. And it's page 750.
Yes.
And it was the passage that I think I referred to already, while the Strasbourg, just above B in 22, has the luxury of looking back at particular circumstances, deciding whether there's been a breach. Our national law has to devise a scheme which will be generally applicable for the impact of the decision is known. As Lord Justice Dyson put it in the Court of Appeal, the question whether Article 8 is engaged should not be decided by examining on a case-by-case basis the actual effect. And then it's 23. The difficult question is how the requirements of Article 6 apply. It's a well-known principle. Decisions which determine civil rights and obligations may be made by administrative authorities, provided there's then access to an independent, impartial tribunal. Full jurisdiction, what amounts to full jurisdiction, varies according to the nature of the decision, does not always require access to a court, even for the determination of disputed issues of fact. Much depends on the subject matter of the decision, the quality of the initial decision-making process. The classic exercise of administrative discussion, even though determinative of civil rights and obligations, a number of safeguards to ensure that the procedure is in fact both fair and impartial. Judicial review may be adequate, even though there's no jurisdiction to examine the factual merits. And finally, of the domestic cases, I would go, if I may, to the draft speeches in Croydon, recognising that they are draft.
Opinions, I think the
Opinions,
correct word is now, rather than speeches. Judgments. We don't make speeches anymore.
But this was in the House of Lords.
No, it wasn't. It's a draft judgment to be given by the Supreme Court.
Oh, I'm so sorry.
I think if you're looking at the same thing as
I'm
I
getting
think you'll be.
completely confused.
Anyway,
Draft opinions. I hope I should not make that mistake again.
Which volume are we looking at?
It's been put into the landmark
Right.
chambers
Yeah, thank you.
additional volume.
Yes. Draft judgment.
Well, we're all in a bit of trouble if they change between now and Thursday, aren't we?
A little bit, but since I'm only going to refer to the speeches of Milady and my Lord, the opinions, there are. I won't make that mistake again. I did it immediately. Very briefly, paragraph 36. This is in the speech of my lady.
Done it again.
I find it very, very difficult.
Sorry.
36.
36.
36, in the opinion of the lady, just refers to the proposition that the distinction between civil rights, private and public law has long been abandoned, the concept extended, but with that extension has gone some modification of what Article 6 requires. And 44 to 45 reluctant to accept Article 6 requires the judicialisation of claims to welfare services of this kind. Unlike the arguments based on statutory construction and jurisdictional fact, Mr. Howell's argument cannot sensibly distinguish between determination of age and other criteria. Every decision about the provision of welfare services has resource implications for the public authority. Public authorities exist to serve the public. They do so by raising and spending public money. The officers making the decisions cannot be regarded as impartial, and the problem cannot be cured by the ordinary processes of judicial review based upon the usual criteria of legality, fairness, reasonableness, or rationality. Tribunals will have to be set up to determine the merits of claims to children's services and so on, many more. Resources which might be spent on the services will be diverted. Conclusion, if not difficult, if not impossible, to reconcile with Runa Begum. The degree of judicialisation depends on the nature. If this is a civil right at all, therefore, inclined to hold it rests at the periphery of such rights, and the present decision-making process, coupled with judicial review on conventional grounds, are adequate.
Yes.
And finally, at 55, and this is, I think, now in my Lord's opinion, 55, dealing with Runa Begum, that case exposed about a third of the way down. That case exposed more clearly than any earlier case the interrelation between the concept of civil rights and the requirement of independent and impartial tribunal. The narrower the interpretation is given civil rights, the greater the need to insist on review by a judicial tribunal exercising full powers. Conversely, the more elastic the interpretation is given. The more flexible must be the approach to the requirement of over-judicialisation of welfare schemes is to be avoided. What the House did in that case was to assume, without deciding, that Runa Begum's domestic right was also a civil right, and made that assumption to hold that the absence of a full fact-finding jurisdiction did not disqualify. And at paragraph 61 of that opinion, Lord concludes, after quoting from Runa Begum, I read this passage as an endorsement of the point, Brian, that Lord Bingham made in Runa Begum, that if an elastic interpretation is given to the Article 6 concept must also be given with the procedural requirements of that article. It's fire, I'm sorry, I should have. Lord, that is all I was going to say on our second submission. I appreciate that sounds like I'm not making very good progress, but it was the overwhelming bulk of what we were saying. Lord, I was going to come on to the precedent point. May my Lord forgive me, but I'm going to put that to one side till after I've done the European cases. Looking at it overnight, it seems to be more sensible. And indeed, so much has been gone through that I really don't need to go through much of the European cases. In particular, I don't think I need to go back to Brian. I did, in fact, go to it yesterday and took your Lordship's milady to it.
Yes, we've seen the relevant bits, I think, and they've been quoted again in later cases.
Yes,
so we know what
I wanted to go to the fuller, slightly fuller, but I think I did take your Lordship milady to the relevant paragraphs as a whole. I didn't go to Kingsley, I referred to it. It's volume 6, paragraph 43. Sorry?
Tab 43.
Tab 43. And I can really just go to paragraph 52. It's whether or not, the issue was whether or not the gaming board could find that the applicant was a fit and proper person to work in the gaming industry, having regard to what they had found against him.
So we see the same formula as we see cropping up again and again.
Yes, referred to, though, interestingly, as examples here at 52.
Yes.
Obviously, it's not exhaustive.
Yes.
Well, that's clear from paragraph 45 of Brian itself.
Yes. It doesn't always just, it has come to tend to be slightly quoted as if it's a formula in some of the others. That was my only point. 53, the court notes the present case concerns the regulation of the gaming industry, which, due to the nature of the industry, calls for particular monitoring undertaken by the gaming board. Subject matter of the decision appealed against was thus a classic exercise of administrative discretion. That does say what is meant here. It is referring to the nature of the scheme. And to this extent, the current case is analogous to Brian, where planning matters were initially determined by the authority and then by an inspector, and to X, the applicant was held not to be a fit and proper person to be chief executive of an insurance company. The court does not accept the applicant's contentions that because of what was at stake for him, he should have had the benefit of full court hearing on both the facts and law. Even though the members of the panel were not experts, they were advised by officials who were. And the court finds administrative regulation of the gaming industry, including questions of whether specific individuals should hold particular facts, to be an appropriate procedure. Again, we got the overall judgment following Brian, and here was a fairly clear and important right, employment, which was in effect being taken away by reference to factual matters, conduct. The subject matter of the decision was the public function regulation of gaming. Arrangement of housing is likewise a classically public and in that sense administrative function, and one which is equally necessary, even though, obviously, as we all know, the Convention doesn't guarantee a right to housing any more than it guarantees a right to a job. While I haven't actually gone through SFIO with your Lordship's milady, I don't actually think I need to do so. There's no any other paragraph particular. So often in these cases, it comes down to very little, actually.
Well, we were very carefully introduced to it by
Absolutely.
Mr. Gowdy, and so we can...
Yeah. So I'm not actually going to turn that up.
Yeah, thank you.
I don't think there's anything to get out other than what we've already said, in particular with respect to Crompton.
Yes.
In our submission, not only should not be said to have been decided regardless of the impartiality issue, but cannot be on any sensible reading of it. cannot be treated as if that was an incidental finding. If it was only about a fact which to some extent is relevant in Crompton, it would have been wholly irrelevant. But to the contrary, in our submission, it seems this was the critical element, especially when we bear in mind that Bryan and Kingsley were both fact cases, and led to, of course, the result that the schemes were, the process was acceptable. Crompton is in volume 6 at flag 37. I'm really only going to look at that. Again, it was introduced, and I did refer to it yesterday and introduced the, insofar as it is a scheme, we know what it is, the Army Board process of complaint. The need, at paragraph 71 on page 12,
well, we have the phrase "such factors as." It's the same point as you were drawing to our attention.
I was just going to say it's an overall judgment.
Yeah.
Subject matter of the decision safeguards impartiality and fact, all embedded within that. At 72 onwards, Bryan and Kingsley are distinguished on the basis of SFIO, because on the particular issue in the latter, SFIO, there was no specialist context. That's correct, and it attributes SFIO to the individual case approach, which we of course accept is how Strasbourg proceeds. And at 78 to 79, really just the first sentence of each. In the present application, it did not centre on a question of fact, and at 79, therefore, did have sufficiencies of judicial review was sufficient. We've made our submissions on this case, I think both originally and again yesterday, both when we opened it again slightly when I was going through things. The scheme, if it can be so called, the section 181, was so broad that it is only capable of being determined on a case-by-case approach. The subject and the nature and the subject matter in the particular cases could be simply anything. Nor was the context so overwhelmingly administrative as to dictate the outcome. But the scheme could be saved an appropriate case, as it was, where it was not one of pure fact, i.e. weighing up the broadly three Bryan features. One of them, the scheme, cannot be said to have weighed in favour, if I can use shorthand, of judicial review. Another, the first stage appeal, was satisfactory, the Anderson approach. The third allowed judicial review, again, because it wasn't a fact. While the reasoning does focus on the fact element in SFIO, we've of course not suggested that that's irrelevant at all, only that it does not amount to sufficient to call for departure from the scheme approach under Part 7, and obviously we are concerned about that because we can identify so many Part 7 issues. Lord, that's why I put that before coming on to precedent, because it sort of neatly flows into it. That's all I want to say about them on their own.
Thank you.
Again, we've really made our submission in opening. Crompton, in our submission, cannot be taken to have changed the multi-factored approach of the Strasbourg case law as set out in Bryan. Crompton, the court applied Bryan. That was paragraph 71. The two cases, Crompton and Civ, do not represent new jurisprudence, and that jurisprudence was fully taken into account in Runa Begum and earlier cases, in particular Auchenbury, and it has not been argued that it was not. Nor can the analysis of Sfio in Crompton be taken as making any change to the test. Crompton, the court's analysis resulted in it distinguishing the latter case on the ground that the central issue in Sfio could be a dispute of fact, where that was not the position in Crompton. There was no question of any lack of impartiality, as opposed to a lack of structural independence, in the equation that they were considering in Crompton. Nor was the issue of procedural safeguards at the first stage of any significance. So the factors which were the second basis of the decision in Sfio simply did not arise in Crompton. There's accordingly nothing in Crompton to support the proposition that the Strasbourg jurisprudence has changed since Bryan. Crompton, of course, was a decision of a chamber, not a grand chamber, which Kingsley was. So there's some point to be said there that Kingsley is, to that extent, the superior authority. They both have to be taken into account, but clearly recognise the difference. Lord and Lady, the House of Lords has repeatedly emphasised that domestic courts should follow the clear and constant jurisprudence of the Strasbourg court. I won't go to them. But
well, we don't need to be reminded of the references, they're very familiar.
I didn't think I would, but I leave the Lordship to say that. Of course, my Lord, you also came back to it in Doherty.
Yes.
I don't know if you want to go to paragraph 19 of that. There has to be very good reason to depart. Circumstances in Doherty, as I mentioned yesterday, that McCann had disapproved the majority in K.
So you're really coming on to precedent now, are you?
I have come on to it. I'm
yes,
sorry,
and,
if I didn't make that clear, that was why I said I'd come back to.
And the point is really quite a short one, isn't it?
It is very short. I'm almost at the end of
yes.
it. But there has to be a very good reason. As in Doherty, the court didn't follow McCann and abandon Kay. I appreciate your Lordship made the point that it was a seven-member committee in K overruling or being invited to overrule Kazi, which was 5, and you thought that it might need 9 to overrule K, was the point you make in Doherty. But if your Lordship had thought it was necessary, doubtless you would have said that we need to reconvene to consider McCann.
And I think you contrast that with the Purdy case, where we recognised, the House of Lords recognised that that what had been said in Pretty could no longer stand, and it was a question of accepting that in order to maintain an orderly pattern of events, we had to accept the Strasbourg jurisprudence. So it wasn't a very difficult exercise to think that we ought to accept the Strasbourg case law in that situation.
No.
But you're saying, for the reasons you've already given, that we're not in that position here,
no,
because your point is that Crompton hasn't changed anything,
no.
Indeed Safire didn't change anything, and it all goes back to Kingsley and Bryan and so on, which
it does indeed.
is a constant stream.
Yeah.
Yes.
And there's no constant, there's nothing constant about them. What we're really saying is, one decision in Crompton and its analysis of law relevant to a particular set of circumstances doesn't comprise clear and constant change and sets the bar too low to suggest that one such decision has brought about any significant change. And we respectfully invite the board to be mindful of the need for certainty, both in particular areas and in relation to the standard set of when you will be willing to depart. Naturally, as a local authority trying to administer a difficult area, seek a result that diminishes rather than increases. My lords, my lady, I've done everything except compatibility now, on which I shall also be extremely brief.
Good.
Perhaps don't need to go to it. I was going to go to Gaydon at volume 3, tab 14.
Sorry, I'm not quite sure what we're talking about at the moment. Compatibility. If you're wrong on your arguments thus far, the question then is, can you read this scheme compatibly with the Article 6 ex hypothesi unmet requirement?
Lord, yes. We say no.
Yes. And you say there has to be a declaration.
We say it has to be a declaration. And we're alone on that.
I mean, can I just be clear? Going back to Croydon, and I think really I'm on possibly addressing my colleagues rather than you here. Having decided that the question whether the child is a child is something, is a precedent fact, and therefore has to be capable of being, so to speak, reinvestigated as a primary fact.
We didn't decide that.
Oh, well, there it is. I've misread that part of it. I just thought paragraph, I've lost it, but I thought Baroness Hale suggested that. No?
My recollection is that we decided it purely on the construction of Section 20 of the Children Act, without addressing without needing the precedent fact arguments.
Yes.
Well,
to reach that conclusion.
Yes, I'm sorry.
Although the consequence is, of course, identical.
yes, well, I'm sorry. I'm sorry. Yes, I am indeed corrected. But the consequence is it has to be capable of determination as a question of primary fact.
Yeah.
Now, as I apprehend, but tell me if this is wrong, that was thought possible by the House or by this court, I should say, is being thought possible by this court in this case, by reference what? To the Wilkinson approach, that you can decide this primary fact within the scope of judicial review. That's how I apprehend the position is.
That's paragraph 33.
Paragraph 32 and 33, which refers to Wilkinson. So it's just like Kawaja, which is, of course, a precedent fact case, where in judicial review, the administrative court can decide yes or no, is this immigrant an illegal entrant qualifying for administrative removal under the second schedule, etc., etc., etc. Exactly the same here. But that is possible within the scope, therefore, of judicial review. Well, why then, if you're wrong on the arguments thus far, by the same token, although, of course, we're talking of a Section 204 appeal in point of law to the county court and not judicial review, what's the difference? Why couldn't this question be resolved within the scope of that appeal? That's my question.
Lord, I entirely understand that, and I think yesterday was coming close to sort of raising that myself. The answer for us is that the proposition of precedent or collateral fact has never been advanced in this case. At all. It has never been advanced in this case. And indeed, it was forsworn in Ibrahim at first instance. Now, had it been advanced that a decision, I hazard your lordship has in mind whether or not the letter
Absolutely.
was sent, that was a question of, I've called it precedent fact or collateral fact, whatever one wishes to call it. I'm sure that, I hope anyway, I'm on the same page as my Lord in terms of what we're talking about.
Absolutely.
Had that argument been run, then that would have been a very, very different case than we have come here and have been brought here to meet. If that had been run, there are two things. We would have produced and adduced more evidence, and we would have wished to address it in those terms. But that argument has never been run.
I'm a bit lost, sorry. What more evidence? I mean, I thought just assume the argument was run. It's not for this court to decide what the primary facts are. So I don't see what further evidence could have
But
helped.
there is evidence about the former offers, Lord, on the construction.
I know, but that would all be then for the county court, I mean, on this hypothesis. So what's the additional argument in law that arises?
The argument in law is that this is nothing to do with the Human Rights Act. It's a pure question of collateral fact and domestic law, which has never been argued. So we've come here, and had that been argued, we might none of us be here.
Well, it wasn't taken before His Honour Judge McKenna.
It wasn't taken in the Court of Appeal. It hasn't been taken here. And had it been, then there are arguments over whether it is indeed, which we've not advanced and we've not prepared for, save that I did really sort of anticipate this discussion over the weekend since we've seen Croydon, which has rather prompted the thought, if I may say so.
It really is arguing a point on the tip of a needle, really, this particular issue. I mean, if the position is, as appears to be accepted, that certainly by the reviewing officer, that the two letters were put into the same envelope, and the recipient of the envelope accepted that she got one of the letters, it doesn't require very much imagination to think that it was a reasonable, within a review approach, reasonable decision for the finder of fact to reach the conclusion that both letters were there when the envelope was received.
So I think my Lord Brown is saying that within the approach adopted in Croydon, that would be a matter for the court to determine, as a matter of primary fact for the court.
I mean,
For the purpose of argument.
I'm not sure.
at this stage of the argument, we are assuming that you're wrong on the first 2 points. I mean, I don't indicate at all whether I think you're wrong on the first 2 points, but assuming you are, the best basis on the face of it might be that you're wrong because this is a collateral fact as to whether the letter was received. It's another discrete precondition of the discharge of the local authority's liability. I'm only saying that might be the best argument against you. Why, if that is indeed the basis on which you were to lose issues 1 and 2, could you not say, well, it's perfectly compatible to have this appeal because within it you can do a Wilkinson or a Kawarja, call it what you will.
Yeah.
There is a difference. It's all right, I'm not a Greek bearing gifts, Mr.
I'm not sure which is the gift, because from our point of view, we've spent a lot of time since Friday discussing where to go on this, even though it hadn't been raised, because we did see it coming today, as it were, over the weekend.
In a sense, what everybody saw was that if Article 6 applied and if Article 6 required fact-finding powers in an independent and impartial tribunal, according to law, well then the issue is, can one apply Section 204 in that way? That's what everybody foresaw, and that is in a sense the difference between this situation and the Croydon situation. In the Croydon situation, there was no statutory right of appeal, no process at all. So the only one would have to be by judicial review, which, if required, can be adapted to whatever procedure is appropriate for to determine what it has to determine. In this, we've got a statutory provision that says question of law, which is why you're saying the only answer is to declare Section 204 incompatible, and then the government can go away and think out whether it wants to set up a specialist tribunal to deal with these things, some sensible system rather than clogging up the county court or whatever. Whereas everybody else is saying, oh no, we can in some way or other read Section 204 to enable the county court to do what the county court has to do, just as one did in certain other contexts. We don't have to get into whether this is a precedent fact or not. We don't have to get into all of that. We can just look at Section 204. That is the difference between Croydon and this situation. There is no Section 204.
Yes, I accept that. Lady, going back to my Lord Brown's point, at least as I understand it and as I apprehend, there is a difference, and there's a clear difference between saying Article 6 does require an independent and impartial tribunal for fact-finding exercises. That, of course, we resist strongly. At the other end of the spectrum, there could be an argument, and could have been an argument, that Section 193, 5 and 7 incorporate what might be called precedent or collateral facts, which in domestic law are points that can be taken, as it were, in domestic public law. You can argue that. That argument, we resist a definitive ruling on that, because it has not been argued below, it has not been developed, and we would have wished to argue a number of propositions in response.
Yes.
And produce evidence accordingly. So we're resisting any ruling that it is one. Now, if in the middle of that, in between them, may be this proposition that if this issue, just the letters as it were, not general primary facts, does require, then it can be accommodated by adapting or adopting the precedent fact approach. I think that's what my Lord Brown is saying. I'm just really trying to check that I've understood that.
I think I've already said at least enough.
On that basis, I've clearly said too much, Lord. May I just have a moment?
Yes, of course.
Is there
Do you need more on this? I think we know where we're going on this. Do you need
Lord, in many ways, that's where we got to on our discussions beforehand, not knowing whether we were going to raise it or not. And in relation to the area as outlined by my lady Baroness Hale, who really has synopsised the arguments very fully, and one would only add, possibly, not necessarily, but just as it were for form's sake, that of course the question is not whether these particular words can be read in such a way, because we have the notion that you can read words very differently. It's not about ambiguity. It is about the grain of the legislation. And we say that to confer a fact-finding jurisdiction that does not already exist in domestic judicial review would indeed go against the grain.
Yes.
For the reasons, in a way, if I may adopt them, that my lady Baroness Hale says.
Yeah. Well, thank you very much.
And that's all we have.
Mr. Baker, do you wish to follow? Thank you. Yes, Miss Luton, when you're ready.
Thank you, my lord.
My lords, my lady, as your lordships know, I am going to deal in its entirety with the first issue.
Yes.
That's whether it's a civil right. I'm only going to deal with the second issue to the degree to make some supplementary comments, supplementary submissions to my learned friend Mr Arden's submissions, and then I will deal briefly with the matter of remedy where Mr Arden and I disagree. So far as the issue of is this a civil right is concerned, just so your lordships, your ladyship know where I'm going to deal first fairly quickly with the Strasbourg case law before Begum, quickly because it's summarised in considerable depth in Begum. Then I will touch on Begum in relation to the civil rights issue. Then I will deal with the post-Begum Strasbourg cases, then the Croydon case, and lastly apply the tests to Part 7 of the Housing Act. Now, in terms of the case law up to Begum in respect of civil rights, first of all, it's important just to make clear there is no issue here that the claimants had some form of right. That's not disputed, and therefore the only question is whether it is a civil right within the meaning of Article 6. And it is, as your lordships will know very well, clearly established that a civil right, for the purposes of Article 6, is an autonomous concept. In other words, the way that it's described in domestic law is not determinative of whether it's a civil right or not. And again, to state what is certainly well known to my Lady Hale and my Lord Hope from the Croydon case, Article 6 has extended into what English lawyers would consider two areas, extended into what we would call public law in two ways. First of all, there are a series of cases about public law determinations which impact on private law rights, of which the classic examples are licensing decisions such as Kingsley, planning decisions such as Bryan, and decisions relating to employment rights such as Albert and Lecomte. And into that category also now falls the case of Crompton, which relates to private law employment rights, albeit with the slight complication that it was a territorial army case. That line of cases, in terms of is it a civil right, is not what is in issue today. It's the second line of cases where there is a determination of a claim for a social security benefit, which is being suggested by my learned friends, has extended into Part 7 of the Housing Act. And that line of cases really starts with the decision of the European Court in a case called Felderbrugge, which is in Volume 6 at tab 40. And Felderbrugge was a case concerning Dutch social security benefits which were contributory benefits. In other words, the claimant had made payments under the equivalent of our national insurance scheme, and whether her claim for the benefits fell within the term civil rights for Article 6. And I'll take your lordships in a moment to the key paragraphs, but the point of Felderbrugge was that the European Court found that when it was a contributory benefit, it was directly analogous with a private insurance scheme benefit, and therefore in the same way that a private insurance scheme would give you the right to would give a civil right, and therefore Article 6 rights, if it was a contributory scheme, the same analysis must apply. And that's where one gets to in Felderbrugge at paragraphs, key part starts at page 8, paragraph 32. The European Court looks at the features of public law and says in 32, the first such factor is the character of the legislation. The legal rules governing social security benefits in the context of health insurance differ in many respects from the rules which apply to insurance in general and which are part of civil law. The Netherlands state has assumed the responsibility of regulating the framework of the health insurance scheme and overseeing the operation of that scheme. To this end, it specifies the categories of beneficiaries, defines the limits of the protection afforded, lays down the rates of the contributions and the allowances, etc. And that last sentence is important because it's picked up later in terms of the need for precise and clear rules if one is to have an Article 6 civil right. Then paragraph 33, a second factor of relevance is the obligation to be insured against illness, or more precisely the fact of being covered by insurance in the event of fulfilling the conditions laid down by the legislation. In other words, those concerned can neither opt out of the benefits nor avoid having to pay the relevant contributions. And then in 37 onwards, the court points to the private law features of the right, and first of all, the personal and economic nature of the asserted right, a phrase which comes up again and again in the case law. To begin with, paragraph 37, Mrs. Felderbrugge was not affected in her relation with the public authorities as such, acting in the exercise of discretionary powers, but in her personal capacity as a private individual. She suffered an interference with her means of subsistence and was claiming a right flowing from the specific rules laid down by the legislation in force. For the individual asserting it, such a right is often of crucial importance. This is especially so in the case of health insurance benefits, when the employee who is unable to work by reason of illness enjoys no other source of income. In short, the right in question was a personal, economic and individual right, a factor that brought it close to the civil sphere. And they go on in 38 to talk about the relationship with the employment contract, thus tying it in at that stage into private law rights. And then at 39 onwards, the court highlights the affinities with insurance under the ordinary law. Finally, paragraph 39, finally, the Netherlands health insurance is similar in several respects to insurance under the ordinary law. And then the third paragraph of 39, such differences as may exist between private sector insurance and social security, private sector insurance and social security insurance do not affect the essential character of the link between the insured and the insurer. So stage one in Felderbrugge is contributory benefit, directly analogous with insurance right, therefore civil right.
And the deductions are part of the analysis, deductions at source, which is rather as if you were paying for the thing yourself.
Indeed.
That idea.
Absolutely, my lord. And again, similar in some European schemes to a private insurance scheme. One then goes from there to the extension of that principle for contributory benefits to non-contributory benefits. And that is the case law Salesi against Italy and Manito against Italy. And if I just ask your lordships to look at Salesi, volume 7, tab 52. Just to summarise where one gets to in Salesi, Salesi is a non-contributory welfare benefit scheme for the disabled. And what comes out of Salesi is that the distinction between contributory and non-contributory benefits by 1993, when this judgment was given, was no longer one that could be sustained. And just to put that into a British context, if one thinks of the distinction between contributory benefits that one pays for through national insurance and non-contributory benefits, that distinction has effectively been eaten away since the Second World War and is now very difficult to find in the legislation any principal distinction. So in Salesi, if one goes, I'm just going to take the key passages, if one goes to paragraph 19, where the court is dealing with the applicability of Article 19, it starts by the court referring back to Felderbrugge, And in the third line of 19, at that time, the court noted there was great diversity in the legislation and practice of the member states of the Council of Europe as regarded the nature of entitlement to insurance benefits under social security schemes. Nevertheless, the development in the law that was initiated by those judgments and the principle of equality of treatment warrant taking the view that today the general rule is that Article 6.1 does apply in the field of social insurance. In the present case, however, the question arises in connection with welfare assistance and not, as previously cited, social insurance. Certainly there are differences between the two, but they cannot be regarded as fundamental in the present stage of development of social security law. This justifies following, in relation to the entitlement to welfare allowances, the opinion which emerges from the aforementioned judgments as regard the classifications of the right to social insurance benefits, namely that state intervention is not sufficient to establish that Article 6.1 is inapplicable.
And by state intervention, we're taken back, are we, to paragraph 18, which is the government meets the entire cost of this.
Indeed.
That's the point,
That's
isn't
the
it?
point, my lord, yes. That it's not a there's no contributory element.
Yes.
As in the two cases previously referred to, other considerations argue in favour of the applicability of Article 6.1 in the instant case. The most important of these lies in the fact that despite the public law features pointed out by the government, Mrs. Salesi was not affected in her relations with the administrative authorities as such, acting in the exercise of discretionary powers. She suffered an interference with her means of subsistence and was claiming an individual economic right flowing from specific rules laid down in a statute giving effect to the Constitution. So that's where the law has got to on social security benefits. My lords, for your lordship's note, Manito is at volume 7, tab 48, but I don't think it's necessary to go to that. It effectively repeats the Salesi tests. And in my submission, what comes out of those tests, those case law up to that stage, is that in order to fall within Article 6.1, it needs to be an economic and individual right. It needs to be a right flowing from specific rules. And it needs to be a right arising from a scheme where there is no discretion in the method of meeting the right. So just to counter a submission that was certainly made strongly in Croydon, the issue is not whether the right is something that is important to somebody. It might be very important, but that doesn't make it a civil right. Can I then turn, because I'm doing this chronologically rather than just looking at the European case law and then the domestic case law.
Yes.
If I can then turn to Begum, which is in volume 4, tab 20. Now, it's right to say that the House of Lords in Begum were prepared to assume that civil right, Article 6 was engaged in order to go on to consider whether there was a breach. But they did consider the matter of engagement in some detail, particularly Lord Hoffman, and in my submission it does give a very powerful steer to the approach to be taken. Now, I appreciate your lordships have now looked at Begum twice at some length in this court, so I am going to really do no more than just point to paragraphs.
Yes.
Lord Bingham, paragraph 6, between letters E and F, refers to Filderbrugger and Salesi, and then says to hold that the right enjoyed by Runa Begum is a civil right for the purposes of Article 6 would go further than Strasbourg has yet gone, satisfied by Mr. Sales's argument that the decision of the court would by no means necessarily be favourable to Runa Begum. And in my submission, nothing has changed from there.
Actually, nothing's changed from Mr. Sales's argument in Runa Begum to Mr. Giffin's argument in Croydon to your argument today.
Not very much, my lady, no, I'm sorry.
It's expanded, it's become more elegant, no doubt, and there are more cases to deal with, but the actual structure of the argument is virtually identical.
That's absolutely right, my lady, and I can only apologise for two things. One, I'm sure it's no more elegant, but secondly, that as the new cases have come along, one has to deal with them, but also, of course, that Lord Hope has heard these arguments now at least 3 times, if not many more, and your ladyship twice in very short succession. But there are other members of the court who I have to at least trot through the authorities.
Of course, no, I wasn't.
And I do apologise.
I wasn't in any way criticising you. I realise entirely why you have to do it. What I was struck with, though, is the similarity in the basic shape of the argument, which has been advanced on, shall I say, the governmental side on this issue, going back at least as far as Runa Begum.
Yes. And my lord, my lady, there's one quite important point that comes out of that in my submission. In Runa Begum, which was decided in 2003, it was clear that there was a little diffidence, if I can put it like that, from the House, that matters might move on in Strasbourg. But in fact, in my submission, we are still going back to Salesi and Manito in the mid-90s, and the European Court has not moved on. And in my submission, what that shows is that actually it has now come to a point where this court should say the Strasbourg case law does not say a benefit in kind is a civil right. The Strasbourg case law might say that next week, next month, in 10 years' time, and if it does, we'll have to revisit this issue. But actually, where we are now is that Strasbourg has fixed on a line, as hasn't changed that line now, since Salesi, which is 16 years ago. So
has anybody ever tried to put the benefit in kind to Strasbourg?
Well, not in these terms, my lord, but I am going to show you the unpronounceable Italian prisoner of war case about Article 1, Protocol 1 rights, where the Strasbourg court made clear that so far as Article 1, Protocol 1 is concerned, STEC is the high point. And it comes to, my submission is, you'll see in a judgment of the STEC admissibility decision, the European Court said, let's try and keep Article 1, Protocol 1 and Article 6 in line on this issue. Then somebody tries to put Article 1, Protocol 1 a bit further, and the European Court says, no, let's stick at STEC. So on that side, and my learned friend Mr. Gowdy suggested that the case law on Article 1, Protocol 1 would support him, but in fact in my submission, on the Italian prisoner of war case, it goes quite the other way. It suggests don't push the line any further. Can I then just briefly show your lordships the passages in the other speeches in the House of Lords? Lord Hoffman, who dealt with the civil rights issue after the breach issue, and it starts at paragraph 60, and I would commend the entirety of this part of Lord Hoffman's speech because he analyses the case law, as always, so very, very clearly. But he, at paragraph 67 and 68,
Yes.
highlights the fact that this is a highly discretionary scheme. If you go to the top of page 456 in paragraph 67, the whole scheme is shot through with discretions in which either the council's duty is dependent upon it being satisfied of some state of affairs or can be discharged in various ways of its own choosing. By contrast, in Manito, the court said that the management committee of the local public health service, after verifying that the applicant satisfied the conditions for entitlement to the allowance, should simply have made an arithmetical calculation of the quantum. So the discretionary elements in Part 7 were, in Lord Hoffman's view, extremely important. And it's important to recognise the discretionary elements on a whole series of the stages in the Part 7 decision-making process. And then in 69, in about the sixth line, he makes the same point as Lord Bingham, that to accept this case, a Part 7 claim, as being a civil right, would be to go further than Strasbourg has gone. And then in 70, he says he's not going to decide it. Then looking briefly at the other members of the Judicial Committee, my Lord Hope, at page 73, agreed with Lord Bingham and Lord Hoffman. Lord Millett also addressed civil rights in some detail, and the key concluding paragraphs are 90 onwards, where he deals with Salesi and Manito and Felderbrugge. And 91, he says the present case undoubtedly goes further still. It has 4 features which take it beyond the existing law. It's a benefit in kind, It involves priority between competing claimants for a finite amount of housing stock. 3, the housing authority has a discretion as to the manner in which it discharges its duty. And 4, ultimately the question for determination calls for an exercise of judgment. And then 92, he analyses those, and then at the end he says, Runa Begum cannot be said to be claiming an individual economic right flowing from specific rules laid down in a statute. He then, to be fair, says in 94 that he's persuaded by these considerations that extending the scope of Article 6.1 is a desirable end, but needs to go hand in hand with moderating the requirements in the interests of administration where administrative decisions are involved, and then says, in the unsettled light of the case law, content to assume without deciding civil right.
And Ms. Levin, you suggest in your written argument that where Lord Millet says at paragraph 93 that if such decisions are outside the scope of 6.1, then judicial control can be dispensed with altogether. You suggest that that's wrong because there happens to be a Section 204 appeal in point of law. But why is it wrong? I mean, why couldn't... The point he's making is, unless Article 6 is engaged by these decisions, well, government could simply say, well, terribly sorry, it stops with the review, or indeed you probably don't even need a review within the local authority decision-making process.
Yes, my Lord, I have to admit, when I reread that paragraph over the weekend, I felt I'd been a little unfair to Lord Millet on that point.
Well, that's what I felt.
In the domestic law, undoubtedly there are the protections that judicial review gives. But I'm not in a position to speculate as to whether in other jurisdictions you might have a situation with no protection. And, of course, just referring to case law that I'm sure your Lordship's familiar with, it will undoubtedly have been the case in a case like Geigerzoo's, where unless the case fell within the ambit of Article 1, Protocol 1, the Austrian government could racially discriminate between ethnic Austrians and non-ethnic Austrians, that the European Court would be keen to ensure that that kind of dispute did fall within some kind of control. But it's difficult to take the point any further when, without the specific facts of a particular European case where there hasn't been protection. Here, there is no possible doubt that there is significant judicial protection through the judicial review process and, on the facts of the Housing Act, through the Section 204 appeal. So,
I mean, just assume there wasn't. I mean, assume government simply said, terribly sorry, it's too much of this judicial review and Section 204 appeal about N, but we'll leave the scheme otherwise intact. I mean, is that, on your submission, Strasbourg proof?
well, but my lord, it would be impossible, well, it would be exceptionally difficult, surely, in the light of cases like Anna's Minnick, for the UK government to produce a scheme which did not give rise to judicial review.
I absolutely...
So it might be Article 6 proof, but it wouldn't be judicial review proof. Now, whether or
we
not...
have our own constitutional way of dealing with it,
Yes.
is really what you're saying.
Yeah.
Okay.
And then finally, Lord Walker, who starts at paragraph 108 and who again deals in some detail with civil rights. And the key paragraph is paragraph 114, where he refers again to criteria very similar to those in Lord Millet's speech, establishing 114.1, establishing priority need may call for the exercise and sometimes a difficult exercise of evaluative judgment. 2, a local authority may at its discretion perform its full housing duty in a number of different ways. 3, there are different periods by which accommodation can be secured. And 4, the local authority's duty comes to an end if the applicant refuses an offer of accommodation.
The law on 3 has changed since, hasn't it? The actual law has changed.
I believe that's right, my lady. But
Yes, well, Section 193 was amended, so 3 is not necessarily relevant now, but it... the rest is.
The rest
As
is.
far as 4 is concerned, you really need to read the sentence as a package. That it's if it refuses which the authority are satisfied is suitable, which is the way subsection 5 is worded, isn't it? I mean, it's a combination of things that all go together.
And when I come briefly to look at the scheme, in my submission, that is a very important point, because unlike any social security scheme, this is a duty that can be discharged and the discharge is subject to highly evaluative judgments as to whether or not an offer of suitable accommodation has been made. Now, that's in very stark contrast to income support or the kind of benefits in Silesia Monito, where there would be no question of the civil right having been lost because of an evaluative process. Right. So it fits into this pattern of a very judgmental scheme or evaluative scheme with a lot of what my lady described in Croydon as soft-edged criteria.
Yes. Well, you can see this in the letters that were written, actually. I mean, it's quite interesting that, of course, certainly in Ali's case, the issue of whether or not she actually received the letter is there, although she in fact, it doesn't press the point, as we know. But then a great deal of effort has gone into assessing suitability, and we see the same in Ibrahim, that the concentration, perhaps naturally, the officer is interested to see whether actually this was suitable accommodation in the first place, whether it was a proper offer to make at all.
Yes.
And one can see these issues all merging, rather as the subsection suggests they do.
And one would assume, my lord, although I don't claim to be an expert in housing law, to have the kind of day-to-day expertise of other counsel involved, but one would assume that in the vast majority of housing cases, it'll be arguments about suitability which will come to the fore at this stage. It won't be an argument about did I get the letter or not. It'll be arguments about that flat wasn't suitable for various reasons. And doubtless that's why the Birmingham Review Officer focused on that issue. So, in my submission, Begum, although I freely accept it was Obiter, deal with the issue in a great deal of detail and point to a whole series of reasons why to extend civil right to a Part 7 claim would be to go beyond Strasbourg. I turn then to the post-Begum cases, and reliance is placed by my learned friend Mr. Gowdy, as it was by Mr. Howell in Croydon, on that series of Russian and Ukrainian cases, all of which substantively concern state housing in various forms. But as Lord Hope and Lady Hale both referred to in the Croydon case, each one of those decisions is actually about the enforcement of a court order, or, to put it more precisely, the palpable lack of enforcement of a court order within the relevant judicial systems. And none of those cases refer to Felderbrugge, Silesia or Monito line of case law. I'm only going to go to one of them, just to make the point good. There are a lot, and they're all rather repetitious. But if I go to what I think is the first, which is Teterini and Russia, Volume 7, Divider 58, particular favourite because, as your lordships can see from the head note, the applicants were both retired judges, and in 1994 the district court allowed the first applicant's claim against the relevant local authority for provision of state housing for which he was entitled as a judge. No appeal was brought against that judgment, and it became final. Later that year, enforcement proceedings were instituted. Judgment could not, however, be enforced because the authority did not possess any available housing or have the financial resources to purchase a house. By 2004, i.e. 10 years later, the judgment had still not been enforced. And I think that the central paragraphs on the facts, page 3, paragraphs 5 and 6, one sees the terms of the court order, and then the efforts to enforce are set out below.
It's clear that the rules are very precise about what particular people were entitled to in terms of state housing.
Yes.
Well, a judge, you're entitled to this plus some extra
I think
space.
to go off precisely a relevant point to the case, my lady, my understanding is that under the old Soviet system there were very precise per metre allocations depending on various criteria. Paragraph 40 alleged violation of Article 6.1 of the Convention, the Court reiterates that Article 6.1 secures to everyone the right to have any claim relating to his civil rights and obligations brought before a court or tribunal. In this way, it embodies the right to a court, of which the right of access, that is, the right to institute proceedings before courts in civil matters, constitutes one aspect. However, that right would be illusory if a contracting state's domestic legal system allowed a final binding judicial decision to remain inoperative to the detriment of one party. It would be inconceivable that Article 6.1 should describe in detail the procedural guarantees afforded to litigants, proceedings that are fair, public and expeditious, without protecting the implementation of judicial decisions. To construe Article 6 as being concerned exclusively with access to a court and conduct of proceedings would be likely to lead to situations incompatible with the principle of the rule of law, which the contracting states undertook to respect when they ratified the Convention. Execution of a judgment given by any court must therefore be regarded as an integral part of the trial for the purposes of Article 6, see Burdoff and Hornsby. So, my lords, in my submission, that's the ratio of this case. And that is the pattern of all the subsequent cases. They focus on the non-enforceability of the court orders in question. In each case, there is no reference to Felderbrugge line of cases, and there is no suggestion that there was any intention to extend the case law in that respect.
So does this mean that there's a breach of Article 6 whenever the state does not provide adequate means for the enforcement of a judgment, irrespective of the nature of the judgment?
Well, my lord, I'm afraid I can't answer that question. That appears to be the way the European Court has approached it in these cases. But they don't say that that will always be the case. And they simply don't address the issue of the circumstances in which enforceability of a court or non-enforcement of a court order might give rise to might not, I think it would be better to say, give rise to Article 6 cases. So take the classic example where we know Article 6 civil rights don't apply, Ferrazini and tax. The European Court has said in terms, tax disputes do not give rise to a civil right.
Sorry, what doesn't in the...
Tax disputes.
Oh, tax disputes.
Sorry, no, tax disputes. And the case law is absolutely clear. Now, I don't think one can say, in the light of the Tetterini line of cases, if you had a court order in a jurisdiction that said the government must pay back £10 million to somebody because they overpaid taxes, and after 10 years the member government had failed to do it for no good reason at all, I can see there would be an argument on Tetterini that that was a civil right because the non-enforcement of judgments would give rise to the civil right. And I would assume that the member government would argue, oh no, it's not, because the case law is clear that tax disputes don't give rise to a civil right. But I'm afraid, my lord, I can't answer how the European Court would square that dilemma.
There's a hint in the last sentence of paragraph 40 that one really is dealing with an Article 6 situation. It talks about the execution of the judgment as an integral part of the trial for the purposes of Article 6, and it rolls back into the thing and saying it's a bit ridiculous to have all sorts of guarantees about Article 6 as to the conduct of the trial without protecting the product of the trial. And that rather suggests you're in an Article 6 type of case when you're contemplating whether the execution of the judgment is to be regarded as part of an Article 6 protection. Now, I'm not sure where that leaves your argument as to the effect of this case, because they haven't explored the reasons for thinking it was an Article 6 case in the first place.
No,
That's the problem.
That's the problem.
I mean, that was what enabled Mr. Howell to argue very strongly to us in the Croydon case. Well, it's taken for red, because we're talking about the right to a trial.
Yes.
And the right to a trial depends upon its being a civil right. So they've obviously taken it for granted that the trial that they got to get the order depended upon the existence of a civil right.
One can see the logical thrust of Mr. Howell's submissions on that, but there is no hint in the case law that they have actually grappled with that issue at all. And in my submission, if they were just assuming it was a civil right, having thought about it, then it is inevitable that they would have referred to Silesian Moneta. Because there can be no possible question that a benefit such as this goes beyond Silesian Moneta.
Well, to some extent, the discussion is focused by the argument. I don't know, I mean, we're not told very much about the reach of the argument either in this case, or indeed all the others in this group.
No.
They all follow the same pattern, I think, one after the other.
Yes.
They almost mirror each other.
Well, absolutely. All the following cases just rely on this case, and then it becomes a rolling bush of cases.
Yes.
But there's no suggestion, as far as one can tell in this case, that those authorities were ever referred to, or that the European Court ever thought about the issue in that way at all. And I appreciate that Mr. Howell goes from there to say, well, they must have assumed, but in my submission, that's a huge leap of logic.
I mean, you could say that as soon as you've actually got a specific court judgment, then whether or not you previously had a civil right, at that point, that has crystallised into a civil right. Could you not? I don't know. I mean, why not?
I would have thought you certainly could if it had been arbitration proceedings, which, as a result of the contract to go to arbitration, had produced an award which had the backing of the contract. And you would then say, well, the contract it dictates it should be enforced, and by force of the arbitration agreement, there is a civil right to have it enforced.
But I would have thought in that case, my lord, there would be no possible doubt about it, because the contract would give rise to a private right, which would undoubtedly be a civil right.
Yes, but one wouldn't worry about Article 6 as to the way the way the arbitration was conducted in the private proceedings, the private arbitration proceedings.
Well, Article 6 would undoubtedly be engaged,
would,
and then there'd be a
yes.
question of whether it was
Absolutely.
met. I think that having been through somewhat of the same thought processes, I think the trickier question might come in an area of pure public law,
Yes.
where you get a court order that the public authority does something very specific, and then that is simply not enforced. And there's no case law that determines whether that would necessarily give rise to a civil right. I think there must be a very strong argument on the Tetterini line of authorities that it does.
Well, I was just thinking, if in this case the county court judge said, you go and redecide this because you've gone wrong in law, you've got a judgment. If the authority simply said terribly, so we're not bothering to do that, I mean, then you're into this territory.
Well, one may then come into a slightly grey area, my lord, with respect. You might get a county court in this, under the Housing Act, or the administrative court in other fields of public law, saying go away and decide it, or go away and meet your duty, but in a wholly unspecified way. And there would be a strong argument that wouldn't give rise to a civil right. But if you had the county court saying, or it's easier perhaps in an administrative court situation, saying you must give Baroness Hale that flat because that's what you promised her on the basis of a legitimate expectation, then that might well give rise to a civil right. But it's just not
Or it
decided
might
by the
say
European Court.
The only way you can properly exercise your discretion here is to pay X pounds.
Yes.
In ordinary, you just send it back. But there are cases where you go that far.
Yes. It's possible. I would accept on this line of authority,
Yeah.
it's possible that would give rise, the way the European Court would analyse it, is that would give rise to a civil right, the enforcement of the order. And in my submission, that's a much more likely interpretation of these cases than that they were assuming that the substantive matter, that is the grant of public housing, had suddenly gone a huge step beyond Silesian Moneta.
The final sentence of paragraph 40, however, does point in the opposite direction, doesn't it?
To some degree, my lord. But
Do we know what Burdoff and Hornsby?
I'm sorry.
Burdoff and Hornsby. I haven't, confess, looked at those, but they are obvious Article 6 cases, are they, where the trial itself was...
I think Burdock is, my lord. I can't pretend I know Hornsby. I may have checked it in Croydon, but I haven't checked it for today. I'll check.
I mean, in traditional international law terms, this is really a case of denial of justice. And one can quite easily see how it is that if you have a judgment against the state, it would be a denial of justice for the state not to honour that. I mean, even in this country, there's still no execution against the Crown, is there? If the judgment is not a money judgment's not complied with, there's nothing you can actually do about it, is there?
I don't know the answer to that. I assume you could judicially review them if nothing else, but...
Well, what good would that do?
You can mandamus the minister to pay and commit him for contempt when he doesn't.
Yes, exactly.
So I don't know.
But, my lord, I agree with your lordship's overarching point. It reads like a decision about the enforcement of judgments against the state, and where the state chooses not to enforce a judgment, then the European Court will do something about it, and Article 6 is the way to do it. It does not, in my submission, read like a case which is seeking to extend a very precise area of law under Article 6, which is subject to a series of well-known and often referred to authorities.
I suppose one could read the earlier sentences there as just telling us what Article 6 tells us, and saying, well, it has a lot of stuff in it about things being fair and public and expeditious and so on and so forth, and one reads into Article 6(1) the necessary bit about making sure that if it results in a judgment, there is an enforceable judgment, it should be enforced. I mean, it may be going no deeper into the thing than that, just saying what Article 6 is describing, and say, well, we can see that this issue about enforcement is covered by the broad generality of what Article 6 is talking about.
Yes. What they don't do, unfortunately, in paragraph 40 is say anything about why we are in Article 6 territory at all.
No,
They just don't address that. And in my submission, the fair view of it is that the approach the court are taking in all these cases is we've got a judgment against the government is simply not complying with it over a very long period of time. We're going to take steps to stop that.
I mean, isn't it relevant that they also find a violation of Article 1, Protocol 1?
My lord, my recollection is that that's very much about the facts of the particular cases, and that in each case there was effectively a legitimate expectation, as they say in 47, to that possession. And it comes down to an analysis of the nature of the right in question.
When do they say that the right accrued for Article 1, Protocol 1 purposes?
Well, 48 is by virtue of the judgment, was it?
Well, then that supports the view that I suggest, that once you've got your judgment, then you've got an enforceable right. It doesn't... I mean, if you've only got it at that point, I mean, trying to march hand in hand 6 and 1, Article 1, Protocol 1, I mean, you know, that figures then, doesn't it?
Yes, it does depend, I suspect, on the nature of the right that's being given. So what was in issue here was a very different type of duty in terms of providing housing to what appears under Part 7 of the Housing Act. And we see that emerging out of 47 in terms of legitimate expectation and 48 in terms of the social tenancy agreement. And then one goes back to the point that my Lady Hale made on paragraph 5 about the very specific terms of the court order. But the analysis, my lord, is I'm not disagreeing with the analysis. It's only that always on behalf of the government one wants to be wary of the next case. And I don't want to make concessions about the scope of Teterini in terms of some future administrative court order. But so far as today's case is concerned, in my submission, your lordship's analysis fits well with mine.
Yes.
Now, there are two other Article 6 cases on the scope of civil rights, which I should just refer to because my Lord Hope referred to them in the draft opinion in Croydon. That's Woonbrom and Loiseau, and they're both in the additional bundle of authorities. They're both on quite different facts from the present case. First of all, Woonbrom, which is at the second tab. And that is a case which concerned whether or not the Dutch government could change the terms of its subsidy regime to housing associations, in particular in respect of housing, social housing funded by private capital. I don't think it's necessary to get into the precise terms of the nature of the change. It's quite a long section from page 2 onwards of the circumstances of the case. It's all about changing state subsidy to what we would call RSLs, to housing associations. And the housing associations sought to challenge the decision. And one can see their complaint at page 10 of the judgment. The applicant associations complain the council estate cannot be regarded as an independent and impartial tribunal within the meaning of Article 6.1, in that it carries out both advisory and judicial functions. The applicant associations further complain under Article 6.1 of the Convention that they have no access to court for a judicial examination of the lawfulness of the Act of the 31st of May 95 on the removal from the balance sheet of financial support for public housing, since Article 120 of the Constitution prohibits such an examination. And then they also brought a complaint under Article 1, Protocol 1 and Article 14. And then the key passages are at the bottom of page 11. The present case concerns and over onto 12, the present case concerns the allocation of state subsidies based on statutory provisions aimed at financially supporting non-profit making institutions like the applicant associations whose sole aim is to work in the field of public housing. Financial support based on an Act of Parliament. And then over the page, Court considers that in these circumstances the relationship between the applicant associations and the state is mainly of a public law nature. However, the presence of public law features in itself does not exclude that rights and obligations asserted through state intervention have such an impact on an individual's personal situation that these rights and obligations should nevertheless be classified as civil within the autonomous meaning of Article 6.1. And then, in the next paragraph, having regard to the specific position held by the applicant associations, the Court considers that it cannot be regarded as comparable to that of an individual whose personal situation could be directly affected by changes in state policies in the field of subsidy awards. The applicant association's institutional aim and their role in the field of public housing is of a typical general interest character, albeit exercised by legal persons established and operating under private law. Now, that's a very different case from the present, and I'll show your lordships in a moment what my Lord Hope referenced to it in the Croydon case. And then the other authority, just to note in passing, is the next one, Loiseau, which was about an applicant seeking his personal records and whether that was a civil right. And the passage that my Lord Hope referred to in Croydon is at page 5. In that case, it was found, Loiseau, it was found that this was an Article 6.1 civil right. And in the main paragraph on page 5, about 8 lines down after the reference to the law of 1978, the Court said, further, the Court considers that this right is of a private nature Firstly, it concerns an individual right of which the applicant may consider himself the holder. Secondly, the documents requested by the applicant, all of which concern the circumstances of recruitment, related directly and exclusively to his personal situation. So the court there is emphasising the private nature of the right and the individual nature of it, of which the applicant considers himself a holder. And then
He wanted his personnel file so that he could bring some sort of
Yes.
employment claim, didn't he?
Absolutely, and it's not at all surprising that that was a civil right.
Well, it fits within the earlier,
Yes, it fits perfectly neatly within the.
in the earlier list that you gave
Yes.
us, yes. I'm afraid my little volume doesn't seem to have Loiseau in it, but I do remember it quite well.
Oh, I have at least 5 additional copies, my lady, so I'll make sure one is passed to you over the short adjournment.
Thank you so much.
And then, my lords, can I refer to the third case that my Lord Hope refers to, and that is the admissibility decision in Stack. And this is relevant for a couple of reasons. Stack was the case which ultimately went to the Grand Chamber, which dealt with the long-standing question whether, for the purposes of the ambit of Article 1, Protocol 1, a non-contributory benefit fell within the ambit of Article 1, Protocol 1. It was critical because if it did fall within the ambit, then one could argue about Article 14 and non-discrimination. And it had been a long-standing debate as to whether the European Court had got to the point where non-contributory benefits, i.e. those that weren't directly analogous to insurance schemes, did fall within the ambit. And what the court found in Stack was that there was no longer a justification for the arbitrary distinction within Article 1, Protocol 1 between contributory and non-contributory benefits. And at least part of their reason for reaching that conclusion was because Salesi, in respect of Article 6, had at least 10 years before, 12 years before, had found that that distinction was no longer justifiable for Article 6 purposes. And at paragraphs 47 and 48 in the admissibility decision, the court dealt with this matter. 47, the Convention must also be read as a whole and interpreted in such a way as to promote internal consistency and harmony between its various provisions. It is noteworthy in this respect that in its case law on the applicability of Article 6.1, the court originally held that claims regarding only welfare benefits which form part of a contributory schemes were, because of the similarity to private insurance schemes, sufficiently personal and economic to constitute the subject matter of disputes for the determination of civil rights. See Felderbrugger. However, in Salesi, Article 6.1 was held also to apply to a dispute over entitlement to a non-contributory welfare benefit, the court emphasising that the applicant had an assertable right of an individual and economic nature to social benefits. It thus abandoned the comparison with private insurance schemes and the requirement for a form of contract between the individual and the state. And then there's reference to Schuller-Skragen. And then 48, it's in the interest of the coherence of the Convention as a whole that the autonomous concept of possessions in Article 1, Protocol 1 should be interpreted in a way which is consistent with the concept of pecuniary rights under Article 6.1. It is, moreover, important to adopt an interpretation of Article 1, Protocol 1, which avoids inequalities of treatment based on distinctions which in the present day appear illogical or unsustainable. So that's where the court's saying the two articles should go hand in hand. And then my learned friend, Mr. Gowdy, goes from there to suggest, well, Article 1, Protocol 1 would support his analysis that benefits in kind, such as those under Part 7, fall within Article 1, Protocol 1. And for that purpose, I've brought an additional authority, which should be on your Lordship's desk, called, it starts Associazione.
Is this the one that ends with Germany?
Ends with Germany, yes.
Right.
And my Italian does not stretch to what goes in the middle.
It's the War of Liberation, something to do with War of
Yes,
Liberation, isn't
well,
it? Yeah.
it's quite clear from the facts, because what this case is about is a German compensation scheme for forced Italian labour during the Second World War.
Or
But-
even the third.
I think it
Third or first?
Yes.
I think it was limited to the second.
No, it's
I'm
first.
looking at the heading. Seems to be first.
Although
I
the
think-
dates rather suggest.
I
it
think
was
that's
the
a
second.
mistake. Well, I hadn't
I
noticed
think
that,
so,
but I'm
yeah.
pretty
You're
sure it's a
right,
mistake,
you're
my
right.
lord.
I'm
It's
talking
all
about
about the Nazi
1943.
regime.
Yes.
So it's plainly a mistake, and it should be the second.
Yes. I'm sorry, I've never spotted that. Yes, it's all about the Second World War, and it's about the period when the Italians and the Germans fell out, and the Germans forced a number of Italians to go to Germany to work as forced labour. But the point of the case is that the scheme excluded prisoners of war, and the claimants were prisoners of war. And they argued that the claims fell within the ambit of Article 1, Protocol 1, and then they sought to argue under Article 14 that it was discriminatory without justification in respect of prisoners of war. And one can, paragraph 16, on August the 11th, 2001, the Applicants Association of former Italian military internee and Mr Farini, who'd been subject to forced labour as a civilian, lodged a constitutional complaint, and one can see at the top of page 149, bottom of page 148, the conditions of eligibility, and it was the third limb, which was the problematic one. Prisoner of war status does not entitle to benefits. So that was the substance of the complaint. And then if one goes to page 156, and can I apologise for the sidelining? I'm afraid I took these out of the RJM bundle and they were all marked up. Page 156, paragraph 75.
Yes.
The court had already found that the Italian military internees cannot claim to have a legitimate expectation of compensation for the detention and forced labour, and that facts at issue therefore do not fall within the ambit of Article 1, Protocol 1. This finding is not contradicted by the court's judgment in the case of Stack. In that case, the court held that non-contributory social benefits funded by general taxation fall within the scope of Article 1, Protocol 1. The court decided that although that provision does not grant the right to receive a social security payment of any kind, if a state does decide to establish a benefit scheme, it must do so in a manner compatible with Article 14, subsequently confirmed by the Grand Chamber. However, the present case is distinguishable from the case of Stack for the following reasons. It's true that both the present case and the case of Stack concern non-contributory benefits which are partly funded by general taxation. However, while the case of Stack dealt with a supplementary regular payment and a regular retirement pension in the framework of social security, the subject of the instant case is a one-off payment granted as compensation for events which had occurred even before the convention entered into force and represented in a wider sense a settlement of damages caused by the Second World War. The payments were made outside the framework of social security legislation and cannot be likened to the payments in Stack. So, my lord, so far as I'm aware, this is the only post-Stack case on Article 1, Protocol 1 that takes the matter any further forward. But what it makes clear in terms is that Stack was not intended to open the gates on our ambit of Article 1, Protocol 1 to any form of state assistance or benefit in whatever form. And in my submission, if the European Court is drawing a distinction between a cash payment made to forced labourers in the Second World War and saying, well, that's outside the confines of Stack, then in my submission, it would necessarily follow that a scheme with a series of evaluative judgments where the benefit is a benefit in kind would also fall outside the terms of STEC. Now, it's quite right to say there are other issues that arise in the Italian case that don't arise here. And one can say there were a number of factors. One was the fact that the scheme had come into related to events well before the convention, and the other was that it was a very particular factual situation. But in my submission, it gives the lie to my learned friend, Mr. Gowdy's submission, that STEC means that any state benefit of whatever form now falls within A1, P1, and therefore within Article 6.
Well, can I be sure I've really grasped that? Halfway through 77, the fourth line, they're talking about STEC and saying that it's, for the reason given, is in the framework of social security, which is plain enough. And it's also plain, I think almost self-evident, that the compensation they're talking about there was outside social security legislation. It was a one-off thing, and that's really an idiosyncratic award. But is the point against you not this, that we're dealing here with something that was it is plainly within the framework of social security legislation?
No, my
you
lord,
don't accept that.
Within the meaning of social security here, it means social security benefits payments, and in my submission that's clear from what they're saying about regular payments, regular retirement pensions. So the distinction they're drawing is between what we would in the UK call a social security scheme, income support, job seekers allowance, disability living allowance, those kind of things, and in the Italian case, one-off payments for effectively compensatory payments, but here, equally, something, in my submission, Part 7 would certainly not be described as a social security scheme. It would be described as a social welfare scheme. Yes. And there's a critical distinction there, well known both in English law and in European law. Yeah. Social welfare schemes would cover anything that involves helping, I'm going to put it in very non-technical terms, but helping the needy in society. Social security are the financial benefits which the state awards to people who meet the entitlements.
Well, the whole argument, of course, was conditioned by the fact that they were talking about a payment.
Yeah.
And all right, you've got the one-off payment, and then you've got the scheme which provides for payments. So at one level, the distinction is drawn simply because there was the framework of social security which provided the background in STEC, which was absent in this case. Does it take on it really any further than that?
I only rely on it to go this far. The European Court here has sought to limit STEC. Now, it sought to limit it on the facts of the Italian case. And clearly, Part 7 raises different factual issues. But the European Court has said, yes, we did this in STEC, but we didn't mean it to go any further than that. And my learned friend, Mr. Gowdy, yesterday suggested to you that the case law on Article 1, Protocol 1 assisted him in saying that Part 7 rights were civil rights for Article 6.
I mean, we're not sure if the court in this Italian case was saying we didn't intend to go any further than we got in STEC, or contrary, we didn't intend to go as far as this case would require us to go. I mean,
no.
So I mean,
I have some difficulty understanding why STEC was relevant here, because what this case was about was the German law which put into effect the agreement between the United States and Germany for compensation to civilian forced labourers. And the case was decided, as far as I can see, ultimately on the simple point that former prisoners of war didn't have any Article 1, Protocol 1 rights because they weren't included as beneficiaries under that scheme. So why was STEC relevant?
It's a little bit subtler than that, my lord, because for which one needs to be embedded in the case law around STEC and Kopechki, and they undoubtedly didn't have an Article 1, Protocol 1 right for the reasons your lordship's just given. But the argument that was being advanced in this case, as was advanced in Steck, was I don't need to have the right. I only need to be within the ambit of Article 1, Protocol 1. And in order to be within the ambit, according to Steck, the critical test in Steck for ambit is but for the condition of entitlement which disentitles me, I would get the benefit.
Yes, it's the Article 14. It has to fall within the purview of a right. You don't actually have to have the right.
And if you think, if one struggles with it, that is very difficult with a possession, because the whole problem is, if I don't meet the condition of entitlement, then of course I can't get the benefit. If I'm not disabled, then of course I can't get disability living allowance. The condition of entitlement is integral to whether or not you have the possession at all. And in the case of Kopechki, which is referred to at length in Steck, the test that the European Court posited was the but-for test. And the argument that was run by the UK government in Steck, and then again in the House of Lords in RJM, was that the but-for test simply couldn't be right for social security benefits, because it meant anybody could claim the benefit, not meet the critical test, and then say, I fall within the ambit. And that argument was rejected in Steck by the Grand Chamber, and was then rejected by the House of Lords in RJM. So that's why Steck was relevant, my lord. That particular issue, happily, doesn't need to concern this court today, but that sets the background. And if your lordship wants to understand that, you can see it from the Grand Chamber decision in Steck, and indeed the admissibility decision.
Could I ask you about the other aspect of the unpronounceable Italian case, which obviously was dealing with a scheme which was very, very similar to the scheme in Voss and Poland?
Yes.
We have both of the decisions in Voss and Poland in bundle 7.
61 and 62.
Yes. And of course that was an Article 6 complaint about lack of access to an Article 6 compliant process for adjudicating upon compensation for Polish forced labourers in the Second World War.
62.
Well, yes.
Is it or 61? 61 is...
Well, 62 is the court decision,
yes.
So that's the useful one. And I noticed that there was also an Article 6 complaint in the Italian case, which is dealt with in the paragraphs following the ones that you've drawn our attention to. And whereas the Article 6 complaint succeeded in Voss, it failed in the Italian case. I think I know why, but I would welcome your assistance with this, Miss
I think
Eben.
the answer, my lady, I could be wrong about this, but I think the answer lies in paragraph 84 and may analytically relate back to what we were debating in Teterini, which was that in Voss, if one goes to paragraph 84 of the Italian case, the present case is therefore clearly distinguishable from the case of Voss, in which the court held that a compensation scheme under the Polish-German Reconciliation Foundation for former forced labourers, which is distinct from the system as set out by the Foundation law, fell within the ambit of Article 6 of the Convention. In that case, the court found that the applicant met the requirements and therefore enjoyed, at least on arguable grounds, a right of compensation, subsequently confirmed in the court's judgment. As the applicants were clearly excluded from benefits under the Foundation law and compensation for forced labour was only provided recently by the Foundation law, the court considers that the applicants could not claim to have had a right of compensation even on arguable grounds. And it follows that Article 6(1) of the Convention does not apply to the facts of the present case. So as I understand it, the distinction was that in Voss they met the conditions of entitlement. They had a right, therefore, I can't remember the facts of Voss sufficiently clearly as to whether it had crystallised into a particular amount. But they had that right, and therefore Article 6.1 applied.
At least arguably they had the right, I suppose.
At least arguably they had
That's
the
the
right.
point. Whereas these people are unarguably excluded.
Yes.
And therefore can't claim any right unless they've got an Article 1, Protocol 1 right, which
They didn't.
upheld didn't. But there are words later on about the absence of a legitimate expectation of a property right does not presuppose the absence of a right recognised on arguable grounds within the meaning of Article 6. This is paragraph 81.
Well, that
So
claim...
just because you don't fall within Article 1, Protocol 1, that doesn't mean to say that you don't have something that brings you within Article 6.
No, absolutely.
That must be right.
That must be right, because if you claimed a social security benefit and you had no possible, you didn't have a legitimate expectation to it, but you were, it fell within the terms of Salesi, then you'd be in Article 6 territory.
You're entitled to a proper decision that you're not entitled to the money.
Yeah, you've got no Article 1, Protocol 1 right.
It's quite fine, isn't it? It's quite a fine line between these two cases.
Yeah, yes, and as often in my respectful submission with Strasbourg, there may be a consideration of the merits of the case that go to the conclusion. My Lords, I'm sorry I've taken a long time on those authorities, but your Lordships haven't seen them before, and I'm conscious that as...
Yes, not at all. No, it's extremely interesting stuff.
Yes, it's all historically interesting, if nothing else. So, my Lords, in my submission, the Strasbourg case law in respect of civil right has not progressed any further than that considered by the House of Lords in Begum. And just to touch on Sofio in this context, Sofio was, of course, a case about housing benefit, which is a classic social security scheme, effectively in terms of entitlement, very similar to the income support scheme, but specifically for housing costs. And in Sofio, the UK government didn't contest that Article 6.1 was engaged. And in my submission, very strongly contrary to what my learned friend Mr. Gowdy has said, there is a complete contrast for these purposes between the housing benefit scheme and rights under Part 7 of the Housing Act to housing. Housing benefit is a cash benefit. It is subject to a precise set of legally hard-edged criteria. And once one is entitled, there is an arithmetical calculation as to what one is entitled to in terms of amount. It therefore stands on all fours with Manito. And in my submission, it is utterly different for the purposes of Article 6.1 from the Part 7 rights. Now, before I make submissions on Part 7 specifically, can I just ask your Lordships briefly to look at M and Croydon in respect of civil rights? Of course, the comments in the opinions are obiter. They're because your Lordships tomorrow, day after tomorrow, are going to find against the Secretary of State on, and against the Respondents on the domestic point, but both my Lady Hale and Lord Hope did deal with civil rights, albeit briefly. First of all, Lady Hale at paragraph 39 refers to Runa Begum, refers to the Russian cases, and refers to Salesi. And then in paragraph 40, refers to the Russian cases not being based on any argument. And then at the bottom of page 24, any entitlement under section 21, that's the Children Act, which was an issue in that case, does not depend upon discretion, but it does depend upon an evaluation of some very soft criteria rather than specific rules, and it is difficult to say at what point the applicant may consider himself to be the holder of such a right. Hence, as Lord Walker observed in Runa Begum, if a right such as this is a civil right at all, it must lie close to the boundary of the concept and not at the core of what it entails. If so, this may have consequences for the second question, which is what Article 6 requires. And in my submission, the same points would be made here. If you get a right under Part 7, it is subject to some very soft criteria, and I'll come back to that in a moment.
And that's consistent with Strasbourg guidance, is it? I mean, I know we've been saying it, but is it...
It's consistent. The soft criteria relates to the discretionary, the evaluative and discretionary terms of the right,
yes,
of entitlement to the right.
Yes. No, I follow that point, but it's the boundary point.
Yes, my lord. I'll come... Well, the boundary point in my submission all flows back to Brian and taking into account those different criteria
Right, yes,
on breach.
Yes, yeah.
And I'll come to that when I come to breach.
Thank you.
But yes, in my submission, what Lords Bingham and Hoffman said in Begum about being on the edge and engagement reflecting on breach goes back to Brian, and that in turn goes back to Mr. Bratz's opinion in Brian. Just staying on Croydon for a moment, paragraph 45 of Lady Hale's opinion, if this is a civil right at all, therefore I'd be inclined to hold that it rests at the periphery of such rights. It's the same point again. And then my Lord Hope, who, if I may say so with respect, was slightly more definite on the point, paragraphs 61 and 62. 61, I read this passage as an endorsement of the point, that's the passage in Runa Begum we've looked at on a number of occasions, that Lord Bingham made in Runa Begum, that if an elastic interpretation is given to the Article 6.1 concept of civil rights, flexibility must also be given to the procedural requirements of that article if over-judicialisation of the administrative welfare scheme is to be avoided. But it is important too to recognise that insofar as in Runa Begum, the question if so and at what point administrative welfare schemes fall outside the scope of Article 6.1 was not tested. Safio, as I've said, fell within the mainstream of cases about social security and welfare benefits. In Runa Begum, the House preferred not to take a decision on this issue. 62, there are, however, a number of straws in the wind that have been generated by the decisions from Strasbourg since Runa Begum that suggest that a distinction can now be made between the class of social security and welfare benefits that is of a kind exemplified by Salesi and those benefits which are in their essence dependent upon the exercise of judgment by the relevant authority. The phrase civil rights is, of course, an autonomous concept, see Woonbroom, but it does convey the idea of what in Steck the Strasbourg court referred to as an assertable right. In that paragraph, having declared that the Convention must be read as a whole and interpreted in such a way as to promote internal consistency and harmony between its provisions, and in paragraph 49 that it's in the interest of the Convention as a whole that the autonomous concept of possession in A1P1 should be interpreted in a way which is consistent with the concept of pecuniary rights, the court said, and I've already read your lordships that passage. Then 63, reference to l'oiseau, to a private right, which can be said at least on arguable grounds to be recognised under domestic law, and to an individual right of which the applicant may consider himself the holder, are consistent with this approach. So too are the references in Manito to a right which can be said at least on arguable grounds to be recognised under domestic law, where the court added, the dispute must be genuine and serious. It may relate not only to the actual existence of a right, but also to its scope and manner of exercise. The outcome of the proceedings must be directly decisive with the right in question. Cases where the award of benefit is dependent upon a series of evaluative judgments as to whether the statutory criteria are satisfied, and if so, how the need for it as assessed ought to be met, do not answer that description. The exact limits of the autonomous concept remain elusive. One can be confident that cases where the relationship between the beneficiary and the public authority is of a public law character, as in Woonborough, where the role of the applicant associations in regard to the construction and maintenance of public housing was of a typically general interest character, fall outside the scope. Mr. Howell submitted there's no distinction to be drawn between the forms in which welfare benefits may be provided, but none of the Strasbourg authorities goes that far, and the carefully worded passages from Loiseau and Steck, to which I've referred, seem to me to contradict his proposition. The series of cases about the enforcement of judgments made by the courts about social housing in Russia, to which he referred, of which the latest is Nagovitsin, offer no assistance as to the question whether a duty to provide social housing gives rise to a civil right was not argued. For these reasons, I think it can now be asserted with reasonable confidence that the duty of the local authority under Section 21 of the 1989 Act to provide accommodation for any child in need within their area who appears to them to require accommodation as a result of the factors mentioned in that subsection does not give rise to a civil right within the meaning of Article 6.1 of the Convention. So, my Lords, in my submission, that comes as close as this House or this court in its previous guise has been prepared to come to what is a civil right. Can I then turn to pull those submissions together in respect of the scheme under Part 7 and just point to what in my submission are the three critical elements as to why this isn't a civil right. Yeah. Firstly, the series of highly evaluative judgments along the way to getting the right, and I'll go to those in a second. Secondly, the way the right is met or discharged itself involves discretionary judgments. And thirdly, the circumstances in which the right can be lost or the duty can be discharged involves, again, highly evaluative judgments. So I'm going to take this speedily because your Lordships have already looked at the scheme twice, but in terms of that first heading, the series of highly judgmental decisions along the way to getting the right, Section 100, the Act, of course, is at Volume 1, Tab 1.
Yes.
Section 175 itself involves a lot of what my Lady Hale described in Croydon as soft criteria. Are you homeless under Section 175 involves questions about is the accommodation available? Are you entitled to occupy it? Would it be reasonable under 175.3 for you to continue to occupy it? Then 176 involves judgments about who normally resides with you and who might reasonably be expected to reside with you. 177, whether it's reasonable to continue to occupy accommodation. Judgments about whether it is probable that doing so will lead to domestic violence, which necessarily is going to involve very sensitive issues of evaluative judgment, to keep saying the same thing. And then to skip on to 189, are you in priority need? Again, involves soft-edged criteria under 189.1a, who might you reasonably be expected to reside with? Are you residing with dependent children, or might you be reasonably expected to reside with them? And are you vulnerable as a result of old age? Section 190, intentional homelessness. I'm sure anybody who has sat in the administrative court in the days when these cases came before it will realise how very judgmental and how difficult those decisions are, and a whole series of judgments have to be made as to whether somebody's homeless intentionally or not. Now, My lords, I don't want this to be put too high. I'm not suggesting that you can get in social security schemes some evaluative judgments. Was it reasonable for you to take a job in job seekers allowance? So I'm not saying that these are knockout points individually, but in terms of do you even get the right, this is a very soft-edged set of criteria where there's a great scope for professional judgment all along the way. But the second point is, in my submission, one that does differ starkly from social security schemes, because that involves the way the right is met itself involves a high level of discretion. So the duty under section 1932 is simply to secure accommodation is available for occupation by the applicant.
So it's the indefinite article, is it? You say there? That accommodation.
Yes.
Is that, I'm just trying to get what the point is you're taking from that very short subsection.
No, the point is, all that has to be done is to secure accommodation. Yeah. It doesn't say the form of the accommodation. It doesn't say the tenure of the accommodation. It doesn't say the location of the accommodation. All those are matters of judgment for the local authority. And in my submission, that is in very stark contrast to housing benefit in Sofio or to the disability benefit in Monito, which are simply arithmetical calculations on the financial benefit that accrues. Once you've got your entitlement, then the decision maker simply tots up the elements. And that's in total contrast in my submission to the nature of the duty and how it's discharged in section 1932. And then the third contrast, which again in my submission is very great to any social security scheme, is the way the duty can be discharged in 193, 5 and 7. 5, the local housing authority shall cease to be subject to the duty under this section if the applicant, having been informed by the authority of the possible consequences of refusal and of his right to request a review, refuses an offer of accommodation which the authority are satisfied is suitable for him, and the authority notify him that they regard themselves as having discharged their duty under this section. And then 7, the local housing authority shall also cease to be subject to a duty under this section if the applicant, having been informed of the possible consequence of refusal and of his right to review of the suitability of the accommodation, refuses a final offer of accommodation under Part 6. So, my lords, under this scheme, the right is lost if the view is taken that there has been an offer of accommodation which was suitable for him. And that necessarily involves a huge element of judgment or discretion, however you want to put it, as to whether a suitable offer was made. There is no equivalent to that in housing benefit, for example. You can only lose your housing benefit if you cease to be entitled because you no longer meet the hard-edged criteria. Part 7 is completely different.
I don't think it makes any difference, but just for my own satisfaction, a Part 6 final offer is likely to be, so to speak, better and more permanent housing than maybe so under the Part 7, otherwise under Part 7, in other words, under 1935. Is that right?
I believe that's right, my lord, yes. Yes.
Is Part 6 more precise about what it means by accommodation for that purpose?
In Part 6 is that you get a permanent place, basically, isn't it?
I believe that's right, my lord, unless you fall into the category of an introductory tenancy. But I'll have to come back to your lordships as to how the statutory provisions intermesh.
I was just trying to understand the interrelation between 6 and 7. We looked at it yesterday. I think I'm more or less there.
Well, my lord, I'll check that over lunch
Thank you.
and come back, because I don't want to speculate and get it wrong. So, my lords, in my submission, for all those reasons, we see a scheme under Part 7, which is, although the duty itself is not subject to a discretion, inasmuch as once you have the right, Section 1935 puts a duty on a local authority, not a power, but whether you get the right, precisely the forms of the right, and how you lose the right are highly judgmental, starkly contrasted with anything that the European Court has found falls within Article 6.1. And then finally on engagement, my lords, I do want to stress the point that was made very strongly in Croydon. If Article 6.1 is engaged by a claim under Part 7, then it is very difficult to see why it would not also be engaged by a series of other local authority decisions in the area of welfare. And the most obvious ones are those under the National Assistance Act, to do with either the provision of care, accommodation, assistance in many circumstances. So a decision that somebody requires certain number of hours per week assistance, certain changes to their accommodation, a whole series of other matters, social services assistance, under the National Assistance Act and other social services statutes. In my submission, it would be impossible to draw a line between that and Part 7. Now, there might, in policy terms, some might see that as beneficial, because those are all terribly important things to the people who get those rights. But it is important to emphasise, as was in Croydon, the huge scope of this argument in terms of expanding civil rights beyond social security into social welfare schemes, where there are discretionary judgments as to what rights you get, but once you've got them, you then have a right, and the local authority, or in some cases the central government, would have a duty to provide.
But there are probably rights of review of most of those decisions of some sort.
Well, my lord, probably not. Certainly not in decisions under the National Assistance Act. No, they are only subject to to judicial review.
Yes.
So they're all subject to judicial review. This is subject to Section 204, but none of them are subject to a full fact-finding review, as Mr. Gowdy argues for here. Yes. I mean, there are no, subject to national security, there are no administrative decisions effectively in England which aren't in some way subject to judicial review, but there is no fact-finding tribunal for decisions under the National Assistance Act.
The only example I can think of, and there'll be somebody who can correct me if I'm wrong, of a judicial procedure which has been set up to decide precisely what a person's needs are and to order the authorities to meet them, which is what we're talking about, is the Special Educational Needs and Disability Tribunal, which has that power. Even the school allocation procedures are not quite that, because the entitlement to a school place of some sort is a given in those. But the closest example of what would be required is Sendist.
Yes.
And now the social entitlement. No, it's not social entitlement, it's something else. Yep. Anyway, but that's the only example I can think of.
And that's a real appeal.
Absolutely.
Full
You have factual
appeal.
findings about what this child's disabilities are, what the child needs, what the local authority should provide. But it's the only example, and it was done for reasons quite other than Article 6.
Absolutely. And indeed, I remember some years ago appearing before your ladyship in the Court of Appeal on a case where your ladyship pointed out with some force to my opponent that, in fact, in terms of legal rights, children with special educational needs were in a rather fortunate position.
I'm afraid I did, didn't I? Yes.
Because, in contrast to elderly people or vulnerable adults who are relying on the National Assistance Act, kids with special educational needs do have that fact-finding jurisdiction. But my learned friend's arguments would leave no clear distinction between National Assistance Act assistance and also potentially with a number of education decisions, both in respect of grants, but also potentially in respect of education rights themselves. And of course, it will always be an incremental process, and at each stage, I expect the local authority and possibly the Secretary of State will turn up and say this is a step too far. But at the moment, we have a clear line in Strasbourg, and once benefits in kind under Part 7, with all the evaluative elements I've referred to, fall in, the clear line completely disappears.
Yes.
My Lords, those are my submissions on engagement, whether or not this gives rise to a civil right. Can I then turn to breach? And the starting point is the point touched on with my Lord Hope a few minutes ago, and that is the very close relationship between the issues 1 and issue 2. In my submission, if Article 6 is engaged here, in other words, if it is a civil right, then it is absolutely on the borderline or on the periphery of what is a civil right. And that gives clear indications of the approach that should be taken to whether or not there's a breach of Article 6, in other words, to whether or not there is a requirement for a full fact-finding appeal mechanism. And your Lordships have already seen the references in Begum. If I just refer to the paragraphs, Lord Bingham made this point at paragraph 5 and Lord Hoffman at paragraph 34. And as we've seen a moment ago, my Lord Hope, my Lady Hale made the same point in Croydon. If you're on the absolute edge of whether it's a civil right, then the approach to whether or not a full fact-finding tribunal has to be a more generous one, a more elastic concept. And, my Lords, in my submission, that goes back to Brian, and I'm just going to refer your Lordships to Brian, which is volume 6, tab 36.
I mean, my Lord Hope, personally, I'd be very grateful just for showing the passage which supports the undoubted, repeated domestic emphasis on that.
Well, my Lord, there's just a point on Brian that your Lordships need to note. What your Lordships have got at tab 36 is the court judgment, but what unfortunately has been missed out of that is the consideration of Mr. Bratzer, which lay behind, who at that stage was the Advocate General. It was on the Commission, wrong court. I've handed in.
Yes, we've got a separate sheet.
Full, yes. This is, I'm afraid, repeats the full judgment, but also has the opinion of Mr. Bratzer. And that is critical for those members of this court who haven't been round this block at least 10 times, because when Lord Hoffman in Alconbury makes extensive reference to Brian, most of what he's referring to is actually Mr. Bratzer's concurring opinion. So in order to understand in order to understand Alconbury, you need to have the full decision in Brian and not just the judgment.
Right, so we can put volume 6 away, can we, or are you going to...
Well, only, put it away unless your Lordships have already marked it up, in which case you may want to cross-refer. The critical passage in the judgment is paragraph 45, which your Lordships have already seen at least twice.
Sorry, when you said Lord Hoffman, this is Lord Hoffman in Alconbury, right?
Lord Hoffman in Alconbury.
Yeah, that's all I want. Thank you.
Goes to a very long explanation of where the law's got to, and a lot of that relies on Brian, and a lot of that is relying on Mr. Bratzer, as he then was, his analysis in his concurring opinion. Right. And that comes out in the judgment in Brian in paragraph 45, which your lordships have already seen.
Necessary to have regard to matters such as. That's why it's a
Yes.
non-exhaustive list.
That's right. The point my lady made, it comes out from Brian itself that it's a non-exhaustive list. And just before I go to the concurring opinion in Brian, in my submission, the thrust of understanding Article 6.1 breach and where my learned friend Mr Gowdy goes wrong is that what the European Court is saying, Brian, is you can't cherry pick one of those factors and say, oh, because of that factor, there has to be a full fact decision. You have to see the thing holistically and look at all of the factors. If we go to the full report in Brian, the opinion of the Commission starts at page 351. And then the concurring opinion of Mr Bratzer at page 353. And if I just read that through, I think maybe the most efficient.
Yes.
I share the view of the majority of the Commission that on the facts of the present case, the only challenge to the enforcement notice which the applicant pursued in the High Court related to matters of planning policy, and that consistently with the Court's reasoning in the Zumtobel case, Article 6 does not in any event require that a court should have the power to substitute its view for that of the administrative authorities on matters of planning policy or expediency. It is said that the reason why the applicant did not pursue his appeal under ground B of section 1742 may have been the fact that the court's powers of review were too limited to justify pursuing the appeal. Now, if we can stop there and I can try and explain the planning law that goes behind that. Brian was an enforcement case, and the relevant power of appeal against an enforcement notice at ground A was that you should get planning permission. So that necessarily involved considering planning policy. But ground B is that it is a ground which necessarily involves considering the facts, because it involves, the question under ground B is whether there has been a breach of planning control. So it is not a question actually of planning policy, it's a question of considering the particular facts of the case, and one can see that from paragraph 10 of the Brian decision, going back.
The court decision.
The court decision.
Page 346, isn't it?
Page 344 to 5,
Right, well,
and then at the top of 345, the appeal on ground B.
Yes.
And this is the inspector's report. What I need to decide in respect of this ground of appeal is whether, as a matter of fact and degree, the buildings could, from their appearance and layout, be considered to have been designed for the purposes of agriculture.
yes.
So a ground B appeal is a fact appeal.
I'm terrible, this is my fault entirely. Page what?
345, my lord.
I'm so sorry.
It was my fault. It's the very top of 345.
It's the very top of 345.
I see, yes, I got it.
He explains what a ground, the inspector explains what he has to do under ground B. I don't think we need to worry about it any further than that. But that just explains what Mr Bratz is talking about. If we go back to 354.
These were the barns that looked
Barns that looked
surprisingly like houses.
Exactly. Not an unusual situation in planning. So going back to 354,
Yes.
however, as the Commission, top of the page, correctly notes, this is a matter of surmise only. The reason for withdrawing the ground might equally have been a recognition on the part of the applicant that the primary facts found and the conclusions reached by the inspector on the basis of those facts were so clearly correct as to be unassailable, however wide the review powers of the High Court. However, I also find that there has been no violation of Article 6 in the present case on the broader ground that the powers of review in the High Court under Section 289 of the Act are sufficiently wide to satisfy the requirement held by the Court to be inherent in Article 6 that the judicial body determining the applicant's civil rights and obligations should have full jurisdiction. And just to stop there, the Section 289 power is effectively the same as judicial review, same as Section 204. It's appeal on point of law.
Point of law, yeah. Yes.
It appears to me that the requirement that a court or tribunal should have full jurisdiction cannot be mechanically applied, with the result that in all circumstances and whatever the subject matter of the dispute, the court or tribunal must have full power to substitute its own findings of fact and its own inferences from those facts for that of the administrative authority concerned. Whether the power of judicial review is sufficiently wide to satisfy the requirements of Article 6 must, in my view, depend on a number of considerations, including the subject matter of the dispute, the nature of the decision of the administrative authorities which is in question, the procedure, if any, which exists for review of the decision by a person or body acting independently of the authority concerned, and the scope of that power of review. In my view, the powers of review of the High Court, when combined with the statutory arrangements under the 1990 Act for appealing against an enforcement notice, satisfy the requirements of Article 6.1. And it's that passage which then finds its way into the court judgment at paragraph 45.
Yes, the matters such as.
In matters
yes.
such as, yes.
Would that be a convenient point to
It
break?
would, my lord, yes.
Well, we look forward to hearing further at 2 o'clock.
Certainly.